Yes, let's proceed with the study session.
Thank you. Can I get the next slide, please? Welcome everyone to today's Board of Adjustment public hearing. This study session is currently in session. Today we have 4 cases that are going to be presented to the Board of Adjustment. Before we get into our case discussion, we do have a case coming up for next month's public hearing that's going to be held on February 26th. It's a residential property seeking a setback reduction for a carport. At this time, I would like to see if we can find out from the board members who is going to be able to attend that meeting. And I'll start out with you, Mr. Chair. Are you going to be able? Okay, thank you. Ms. Schubert?
Yes.
Thank you. Mr. Marks?
Yes.
Thank you. Ms. Paulus?
Yes, I'll be here.
All right, thank you. Okay, getting on with today's case discussion. The first case we have on the agenda is Taylor Residence Detached Workshop and Shed located at 3438 North Wilson Avenue. This is a appeal of a DDO decision. Next screen, please. So essentially we have a property that's developed with a residence, an attached workshop, and a detached metal building. The property owner applied for a DDO in order to keep the workshop and the metal building in its current location. The DDO application is a process that allows a setback reduction of the structures. The DDO process went through. There was a decision issued for approval to allow the structures to remain with the reduced setbacks. Next slide, please. So what you're seeing on the screen now is the aerial view of the property, and then some shots of the facades. We have the west-facing facade, which is the front of the workshop, and then we have an east-facing photo that shows kind of the backside of that workshop, and then along facing that is also a shed. And then below you see the elevations of the shed there. Next slide, please. So here are the 3 setback modifications that were part of the DDO process. One was to reduce the perimeter yard setback for the workshop from 20 feet to 1 feet 6 inches, and that's to the north lot line. Also, the second setback reduction is for the shed to be reduced from 20 feet to 4 feet 6 inches, and that is also measured to the north lot line. And then a rear perimeter yard setback reduction for the shed from 20 feet to 8 feet 4 inches. The matter before the board today is that there is a property owner, the appellant, Ms. Maureen Pollock, appealed the directors of the DDO decision finding noncompliance with findings as indicated in the staff report. And so the matter is before the board to determine if there was an error in the director's decision to approve. As part of the Board of Adjustment appeal process, this was heard before the Design Review Board on January 24th. The results of that January 24th meeting was that the Design Review Board recommended upholding the director's decision. At this time, we have received 28 comments opposing the appeal and 1 comment that's supporting the appeal. And you do have those comments that were emailed to you. So at this time, I'd like to go ahead and open it up to any questions that the board might have. Yes, Mr. Marks.
Yeah, the first question has to do with why was a DDO requested in the first place? Was there some action on the part of the owner, such as requesting a permit that was not allowed to be processed, for example, because of the substandard condition that the workshop created? Or was there some other reason that caused the owner to request that DDO at this point? Were we in the middle of some kind of enforcement action?
Mr. Marks, yes, that is correct. There is a code enforcement case opened up on the property. What triggered the investigation was a complaint, anonymous complaint about a fence being erected on the property. Upon code enforcement's inspection of the property, they also found several issues with work being done without permits. As a property owner was in the process of renovating the property to bring it, make it rentable. And so the property owner submitted permits to get the work in compliance. And that's when it was found that the existing structures did not have permits or zoning approvals. So that is part of this process, is to get those zoning approvals and get those permits issued so the property owner can continue to make those renovations and bring the property up into compliance with code.
But as far as the status of the one building in question that is the subject of the DDO, that being the shed in the rear, were there any plans to modify it or to expand it?
Mr. Chair, I'm sorry, Mr. Marks, there's actually two structures that were part of the DDO request. That's the attached workshop and the detached shed. And so there are no plans to do any expansion to any of those buildings or those structures. It's just to bring them into compliance.
So the structures in question have existed for quite some time.
Correct. They have been in existence since since the property owner took ownership of it. I believe the shed shows up in aerial photography around 1998. And then the workshop shows up maybe around 2002 with additions 2010 and 2012 subsequently.
Okay, so the bottom line, the DDO does not allow for any new construction that might be in conflict with the code. It merely recognizes and confirms the existing structures.
Correct. This is just for existing structures. There's no new development proposed.
Okay, I think that's all the questions I've got. Thank you.
Ms. Paulus, anything? Okay, thank you. If there's nothing else on this, I'd like to go ahead and move on to the second case. Okay.
I have one question, I'm sorry.
Oh, sure. Go ahead, Mr. Chair.
Just a question of curiosity, really. Were this motion to fail and the DDO would be overturned, what would be the consequence of that?
The structures would have to be removed or modified to meet compliance.
Thank you.
No, I think so. Okay, next slide, please. We'll go into the second case. So 2408, this is a Chick-fil-A, a new awning located at 4585 North Oracle Road. So this is also an existing property located at the southwest corner of Oracle and Auto Mall Drive. This project is a renovation of the property. Basically, they're redoing the parking layout and they're adding a shade structure over the drive-through. So what's triggering the variance before the board is that the shade structure is not going to be meeting setbacks to Oracle Road. So the matter before the board is that the property owner is requesting a reduction of the street perimeter yard setback from 10 feet to 4.5 feet, and that's measured to the street lot line along Oracle Road. And for this particular case, we've only received one comment in support of the variance request and no protests. I'd be open to any questions anybody has on this project. Yes, Ms. Paulus?
What's the purpose of a street perimeter yard? Is it for safety, for a sidewalk, for landscaping, for site visibility? What's the purpose of needing that additional space beyond the right of way?
It's a little bit of everything, what you just mentioned. So it's safety, also includes any providing space for road expansion, street improvements, walkability, things like that. In this case, this structure is not encroaching into that right-of-way area. It's just encroaching into this building setback.
Could you just repeat what the variance is? You're saying it's a reduction of the street side yard, the side yard setback from what down to what?
It's a reduction of the street perimeter yard from 10 feet to 4.5 feet, 4.5 feet.
Okay, very good.
One more question. Does staff know of any immediate plans by DTM to do any road widening on Oracle in this vicinity?
Commissioner Paulus, we are not aware of any plans to do any widening of Oracle in this location right now. And it should be noted that the Department of Transportation is in the process of reviewing all of the adopted street widths in the city as well. So it's feasible that this actually could be changed in the future to not need as much right of way. I don't have exact details on that, but that's just something to take into consideration. And I do apologize for my voice. I've been sick, so I've lost my voice a bit. So I'm going to try to speak up as much as possible.
You might have said it, but let me just ask this again. Do they have the full half right of way already?
I do not believe they have the full half right of way already, but we can double check that information. It's pretty easy to pull up.
I think the materials said that it's currently 140-foot right of way and the MSNR calls for 200 feet.
I think that's
Future
correct,
right-of-way.
yeah.
So they're 60 feet smaller than the accepted right of way in the MSNR
So that would be an additional 30 feet approximately on
on
each
either
side.
side.
But again, it's possible that in the future, we may not want to have a 200-foot right of way. But again, I don't know the specifics on that because that process is still underway with the Department of Transportation.
Any other questions on this case?
I just had one more question. Why wasn't this applied for as a DDO? It's not a setback. It's a street perimeter yard issue. Is that why it's not a DDO and it's looked at as a variance?
Ms. Paulus, the reason why it can't be processed as a DDO is because it's along an MSNR route. Because it's along an MSNR route, it's a variance is the appropriate process. The DDO process does not allow it.
So the DDO they're requesting for the Automall Drive is acceptable because it's not a arterial or a collector.
That's correct.
Okay, thank you.
Can I get the next slide, please? One more. Thank you. Okay, moving on to case C-10-2409. This is Anderson Residence Accessory Structures located at 1 North Tucson Terrace. So this property is a residential property located southeast of St. Mary's Hospital, and it's on the south side of Silver Bell Road. And as you can see by the aerial there, it's developed with a single-family residence, carport, and some other detached accessory structures like a cistern, a couple of cisterns. This case is before the board because the property owner constructed a fence along the west side without any permits. Code enforcement investigated it. And in addition to the fence not having a permit or zoning approvals, they flagged it for the other accessory structures that did not have permit. So the matter before the board are three, I got the structures circled there. There's three structures in what we call the front yard. There is a attached shade structure, a shed, and a cistern in the front, and then there's the fence along the west side. So regarding the structures in the front, the attached shed and the attached shade structure are not meeting setbacks to the front street lot line. And then there is a detached cistern that is also located in the front yard at the property line. So the variance before the board, can I get the next slide, please? So the variances before the board for this case is to allow the cistern to remain in the front yard, allow the attached shade structure to remain in the front yard with a setback reduced from 20 feet to 2 feet measured to the south property line, allow the attached shed to remain with the front street perimeter yard setback reduced from 20 feet to 6 feet as measured to the south lot line, and then allow the cistern to remain with the front street perimeter yard setback reduced from 20 feet to 0 feet, and to allow the privacy fence to be constructed along the west lot line at a height of 13 feet, which exceeds the 6-foot maximum height as shown on the submitted plans. And you received the comments for this project as well. I believe there was 4 approvals and 0 protests. And I will go ahead and open it up to any questions. None?
So the Silver Bell road alignment was changed in the 60s according to the report. Why wasn't the cistern and the other structures simply grandfathered in when those changes were made?
The cistern showed up later, so it wasn't done without approval or permit. So that's the reason why it's before the board now. No other questions? Okay. Can I get the next slide, please? Okay. And so the last case we have, C-10-2410. This is Clark Residence, new sleeping quarters and shed. And this is located at 345 South Irving Avenue. This property is located just east of Randolph Park on the east side of Alvernon Way. So this property is a single-family residence. It's located just directly across the street from Fire Station 11, consisting of a residence. There's a pool there. There's also an existing detached sleeping quarters. What the property owner would like to do is construct a new addition to those sleeping quarters. And that triggered this case coming before the board. With this new addition, it kicked in the requirements for the 5-bedroom rule, where if you have 5 bedrooms or more, you need to provide your parking spaces in the front of the property. I'm sorry, in the side and rear of the property and not in the front. In this case, it's going to be 6 bedrooms, so they need to have 4 parking spaces. They are requesting a variance to allow the 4 parking spaces to remain in the front yard. And also they're requesting a setback reduction for the new addition to match with what's existing with the existing sleeping quarters, which is 4 feet 2 inches from the north lot line. And then there is a detached shed that also showed up that did not have zoning approval. And because that's located in the front yard, they're also going to need a variance approval for that. So that's, the variance is also to seek approval to allow that structure to remain in the front yard area. For this case, we did not receive any comments. Open to any questions at this time.
Yes, the addition has not been built yet, right? He's seeking a permit for this.
That's correct. Any other questions? Okay. All right, we'll go ahead and adjourn. We'll start back at 1:30 for the public hearing, so 15 minutes. Thank you.
Can't hear it.
And you may speak. The chair may allow the applicant an opportunity for a brief rebuttal. The chair will then close the public hearing and open up a discussion by the board members. At the conclusion of the board's discussion, a motion will be made, and if seconded, will then be voted upon. All presentations today must be directed solely to the board and not to staff or members of the audience. All presentations to the board must also be only on the items brought before the board. Presentation on matters unrelated or requests will not be heard. The decision of the Board of Adjustments may be appealed to the Superior Court of Pima County by filing a complaint to special action with the Pima County Superior Clerk's Office within 30 days of the board's decision. For additional information of this filing process, please contact the Superior Court Clerk's Office or an attorney after today's public hearing. If you are going to give testimony today, please be brief. We have a lot of cases, so again, I emphasize, please be brief and to the point. Repetition of testimony already given by other witnesses is not necessary. The chair may invoke a time limit if deemed necessary. Before you testify, please remember to state your name and address. All testimony of the board must be given under oath. At this time, I'm going to ask the city staff to raise their right hand and repeat if necessary. Do you swear to tell the truth, nothing but the truth? So help you?
Yes.
Yes. Okay, thank you. Okay, thank you. Okay, this is assuming we're online to mute yourself, so good, we're ready to go. May we have the first case, please?
Thank you, Mr. Chair and members of the board. Our first case today is C-10-2407 Taylor Residence Detached Workshop and Shed, 3438 North Wilson Avenue, RX2. The appellants, Maureen Pollack and Linda Wurzelbacher, are appealing the Planning and Development Services Director's decision to approve Design Development Option Case DDO 24-81. Case DDO 24-81 is a request by property owner Dan Taylor to allow an existing workshop and shed constructed without prior zoning approval to remain with reduced side and rear perimeter yard setbacks. The property owner filed a design development option application with the Planning and Development Services Department requesting the zoning approval necessary to allow the construction to remain with reduced building setbacks as measured from the north and east property lines. The DDO application was approved by the Planning and Development Services Director, finding the project in compliance with all required general and specific findings of the Tucson Unified Development Code, sections 3.11.1.d.1 and 2. The appellants are requesting a reversal of the Planning and Development Services Director's decision to approve Design Development Option 24-81, which is a request by the property owners to allow the following modifications. 1, DDO approval to allow the side perimeter yard setback to be reduced from 20 feet to 1 foot 6 inches measured from the workshop to the north lot line. 2, DDO approval to allow the side perimeter yard setback to be reduced from 20 feet to 4 feet 6 inches measured from the shed to the north lot line. And 3, DDO approval to allow the rear perimeter yard setback to be reduced from 20 feet to 8 feet 4 inches measured from the shed to the east lot line, all as shown on the submitted plans. In related plan reviews, zoning regulations require that DDO appeals to be reviewed by the Design Review Board for recommendation to the Board of Adjustment. This appeal request was heard by the Design Review Board on January 24th. The Design Review Board recommends to the Board of Adjustment to uphold the Planning and Development Services Director's decision to approve DDO 24-81, finding the modifications in compliance with UDC sections 3.11.1.d.1 and 2. Planning and Development Services staff recommends upholding the decision by the director to approve the design modifications requested in case DDO 24-81. It is the opinion of staff that the project is in compliance with the UDC section design development option findings for approval. To date, we have received a total of 1 comment supporting the appeal from outside the notice area and 28 letters opposing the appeal, 8 from which are outside the notice area. For the record, board members have been provided copies of the comments. Mr. Chair and members of the board, this concludes staff's presentation. I'd be happy to answer any questions.
Thank you. Are there any questions for staff?
Yeah, I've got one question, and that is, where is the appellant located? Is he or she an abutting property owner?
Mr. Marks and members of the board, the appellant is located just outside of the notification area.
Not even within the notification area.
That's correct.
Okay. Okay, thank you.
Mr. Castro, I have a question. The workshop's been described as having a dirt floor and a number of other issues. Does that structure meet building codes?
No, it does not.
Is it going to meet building codes?
Yes, as part of this permit process, it's going to need to comply with all building code criteria.
So normally when a structure is being remodeled to a great extent, isn't that when we bring things into compliance?
That's correct.
So this DDO was a way to bring it into compliance?
Just as far as the zoning portion is concerned, and that's the building setbacks.
Thank you.
I just wanted to revisit Mr. Mark's question about the location of the appellant. I think you may have been referring to the original appellant who was awarded the DDO? Or are you talking about the current appellant who is appealing the decision? The latter. Okay, yeah, they are outside the map. Okay, just wanted to clarify that.
Okay. Any further questions for staff? Okay. I will now open the floor to anyone wishing to speak with regards to this case. The appellant. Okay, the appellant can come up and speak, please.
Mr. Chair, the appellant is on Zoom, is on the Zoom call, and she's ready. Ms. Maureen Pollock is here on the Zoom.
Okay, I'd like to have them raise their hand. Are we gonna see this person? Okay, thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Would you please state your name and your address?
Yes, my name is Maureen Pollack, Pollack, and I reside at 2000 East Greenlee Road, Tucson 85719.
Okay, thank you. You may proceed.
I have a PowerPoint that is I'm supposed to be given um, permission to upload it? Or do I share the screen?
Mr. Chair, may I address the appellant?
Yes.
Ms. Pollock, yes, we are going to give you permissions to share your screen. You should be able to locate a button on the bottom of your screen that says share.
Yes,
And we will go ahead and give you the ability to do that.
all right. Can you see?
No.
It's a share over here too, over. Did they do that again before? A link to the slide? Maybe it says share and it'll give you oh wait, it's uploading. May I get some more instructions because that doesn't seem to have worked for the PowerPoint.
Ms. Pollock,
Yes,
were you able to select the share button on the bottom of your screen?
it doesn't seem so.
Can you email that document to me?
Yes, I'm going to email it to you right now. Remember the name of it? Type in the name, the list. Okay, here we go. Did you see it on here? Oh, here we go. Okay. It's been sent. I've sent that document.
Okay, I'm just waiting for it. Just stand by.
Okay.
Ms. Pollock, I still haven't received that file. You could try emailing it again, but in the meantime, you can go ahead and start the presentation. And as soon as we get it, we will get it up on the board for you.
Okay. I don't know. Any attachments there? Okay, I've resent it. May I start? Yes. Okay. First of all, I'd like to thank the chair for offering the venue of being able to see this, have this meeting virtually. I have a congenital hearing loss, and spaces like the City Hall chambers are very difficult for me to hear in. And being able to have it virtually, I can see the captions and hear people much better. So I wanted to set the stage because you may or may not be aware of this, but in August of 2022, I submitted a complaint with the code enforcement against the property at 3438 Wilson. The recorded owner of the property at that time were John Berryman and Wendy Kruger, who owned the property as joint tenants with right of survivorship. I complained about the non-compliance of the existing building because the property appeared vacant and was cleaned up for the first time in years, and I thought someone was going to be selling the property, and I didn't want the property to fall into a third person's hands and they would leave the non-compliant structure on the property. By the time code enforcement came out in October, the original applicant, Dan Taylor, had purchased the property, and he had, Mr. Taylor is a licensed general contractor, and he had started construction on the site without a permit. And so codes enforcement found him in violation of several code violations. And he had erected a fence around the property so that you could not see what was actually going on behind it. So we have, so the DDO, original DDO was submitted, but prior to the DDO being reached by the board members of the Richland Heights East Neighborhood Association, Mr. Taylor came to our board meeting on the August 7th, of which he is a board member, and announced to the board that his DDO had been approved, which we were a little surprised about because we had not even been given notice that the DDO had been applied for yet. So the DDO was approved. Linda Wertherbacher and I, another neighbor in the neighborhood, met with Georgia and Mark to discuss the appeals process. And during that time, they told us kind of what we could expect, although just this morning I learned that I was able to submit a PowerPoint, which was great, except that I haven't done PowerPoints in a number of years, and so it is what it is. But we were also told at that meeting that our chances of succeeding in the appeal were very poor. We attended the design review meeting, which was requirement of the appeal, and it felt like the design review board had not been to the property, which I confirmed they had not, and nor had the planners. Everyone has been judging this property on some limited building plans and various aerial views and pictures of the site, which is misleading. Only recently, when I was preparing for this case, I went on to the city website and found site aerial and front views of the property from the Tucson GIS website. And those photographs are very telling because all along everyone has been saying this shed has been there forever, it's been there forever, it's been there forever. And so it gets to stay there because the policy of the Tucson city seems to be, and I've heard it from enough people now that I guess I believe it, is that we forgive. We allow the people to bring the property into compliance and go forward. This particular shed sits on the property line. We have 20-foot setbacks in Richland Heights at the get-go, and then we have various adaptions of that setback, but nobody has a zero lot line property in our neighborhood. This would be a first, and I feel it would be a bad precedent to set. Even the design review board member who did agree with us suggested that allowing this shed to remain at the property line would be a slippery slope and just wrong. And thank you very much for getting this up. So most of these are self-evident. This is what the property looks like today. That picture was taken in 2024 by myself. The other pictures are all from your code enforcement officer and or the GIS aerial views. Do I have control of this? Can we switch to the next slide? Thank you. So this is a picture from Google Earth in 2011, and you can see that the shed building reaches the property line. It's only listed in your documents as being 1.6 feet away from the property line because the owners to the north quitclaimed this 1.6 feet to bring it into some kind of compliance that the city recognizes. Next slide, please. Here in 2008, I got a red arrow there that clearly indicates there is a space between the north fence and the shed. And if you go back one in 2011, if you can go back again, thank you. You can see it's there. So now you can go forward again. Thank you. And you can go to the next one. And this picture is showing the addition that was done from the 2008 picture to the 2011. You can take the next slide, thank you. This is an aerial view from the Tucson GIS of the house in 1998. I've put in the red lines around the property, and that vertical red line in the center shows the distance between the properties. In 1956, prior to anyone owning the property, the current owner at that time requested a permit to put in a carport, which was granted. And they show that 1956 permit as showing 40 feet from that carport to the owner to the north carport. So there's a lot of space there in 1998. Next slide, please. And here we are in 2005. They have built the property to the shed to the wall again. I'm ready for the next one. In 2006, I don't know if you can see it, there's a vertical space that shows that there was a gap between the original house and the shed that was built on the site. Right, yeah, just right a little above there. Thank you, Mark. Next slide, please. And then here, in 2010, you can see that the shed has moved significantly to the east, and the gap between the shed and the original house has been roofed over. The city records on the plan review of June in 2024 indicate, or they don't indicate, they mention that metal roofs have been used to bridge from the original house to the shed, giving the aerial view of looking like it's a very large undercover space. Next slide, please. And then here, 2020 GIS appears as it does today, which was also in the last slide. Next slide, please. This is a photo from the codes enforcement when they went in October 2022. Now, I have been inside this building on at least 4 occasions because I had some work done by the previous owner, and I dropped the items off, picked them up, dropped them off, picked them up. And I would tell you that this property inside that enclosed structure is roughly the size of my garage, which is 390 square feet. You can see through the opening at the end that it's daylight out of there. However, these metal roofs that we see from the aerial indicate that the building is much larger than it is, and it's this larger space that Dan Taylor is trying to get a new workshop built on the property lines for a total of 750 square feet, when it is my opinion, and it's also supported by your plan review of the city, that it is simply a roof covering over the building. Next slide, please. And this is the end. These are my concerns. I'm very concerned that no one has visited this site. Even the codes enforcement officer did not go inside the building, and it was evident at the design review board that there was a lot of confusion based on photographs and the actual plans, which are very, very, very basic. There's no floor plan, there's nothing. So I feel that, and they did say that the Board of Adjustments may visit the site individually, and I don't know if any of you have done that. The next point is that the GIS aerial views were not available earlier, at least not to me. And I think that if the Board of Review and the Planning Committee had used these earlier, they would have come up with a different decision. The building was not always there. It wasn't there in 1998. And in 2008, they were still expanding between the gap and the north boundary line. As I mentioned, the structures appear to be part of this forgiveness policy of the city of Tucson. And it's rather, it's, this forgiveness policy, to my understanding, is not a written law and it's not a codified law. It's merely a general policy. And I could be totally wrong about that, but nobody has ever said the forgiveness policy, section 1, 2, 3, 4. Yet this policy takes precedent over existing city codified regulations, zoning laws, and neighborhood plans. Leaving the structure as it sits sets a bad precedent for our neighborhood where many properties have freestanding sheds on their lots. I just can't understand that the city doesn't provide more support of their own laws and of the neighborhood zoning and neighborhood plans. As I mentioned earlier in the design review board meeting, the one board member who spoke up said it was a slippery slope and just wrong as this DDO was granted. My intent in filing this appeal for the DDO has always been to preserve the Richland Heights neighborhood values and direction as structured in the neighborhood plan and supported by city codes and regulation. To vote to approve this DDO devalues not only the neighborhood, but our individual properties. The planning office is correct that they did send me a bunch of letters in support of this DDO. Most of them were supportive of Dan Taylor and his wife, Jessica. His mother approved of it. A neighbor who is one of his tenants approved of it. His good friend and his friend's tenant approved of it. And the neighbor's daughter who lives in their guest house approved of it among the people who approved. Oh, and one of the original complainants of this property for being used in construction and business also approved of this, of his doing it. And since then, we've had 2 more approvals of eliminating the DDO, which were not addressed. They came in this morning, and we had 3 before that. And just in closing, I'd like to say that it just feels like the board is giving preference to a developer who is not going to live in this building. He lives across the street versus the people who live in the area. And as I said, Mr. Taylor is a licensed general contractor, and he bought this property knowing it was non-compliant. And I guess he was hoping that the city's policy of forgiveness was going to allow him to rebuild a shed into a 750 square foot workshop. Thank you. And that's all I have to say. Thank you.
Thank you. Are there any questions for the presenter?
I have a point of clarification for Ms. Pollock. Ms. Pollock, I thought you made a statement that the workshop was on the property line until the property owner obtained 1 foot 6 inches in a quitclaim deed from their adjacent property owner. Did I hear you correctly?
That is record for the city planning. They have that on record. They were the ones that told me. It was sitting on the property line, and then I was told that the neighbors to the north provided a quitclaim deed of 1.6 feet, which changed which was enough. So, I don't know how that works mechanically, that the 1.6 granted from the neighbors allows it, but you did hear me correctly.
So I'd like to ask a clarification from staff. Under the general findings for a DDO, item 1E says does not result in a deletion or waiver of a UDC requirement. And it states here, according to the zoning administrator, the request is to reduce building setbacks to a measurement not less than 1 foot. A measurement of less than 1 foot is considered a deletion of the UDC requirement. So my question is, by obtaining an additional 6 inches, they were able to circumvent this finding in the DDO?
Ms. Paulus and members of the board, so it is not against the rules to obtain a quitclaim deed if it's something that the adjacent property owner is willing to do. In this case, he was able to get the additional foot that he needed in order to at least obtain a 1 foot setback, which would allow him to go through the DDO process. So this was done before he actually applied for the DDO. Otherwise, if he did not have the 1 foot necessary, it would have been a Board of Adjustment variance.
Yes, I have a question for Ms. Pollock. Is this, are you a member of the Richmond Heights Neighborhood Association Board?
Yes, I am. I sit on the board currently, and I've been on the board probably as long as I've lived in the neighborhood, about 10 years. No, 14 years, sorry.
Thank you.
No, can I ask a question, kind of a follow-up to what you just asked? It sounds like the lady talking is a member of the board, but is she speaking on behalf of the board? That's my question.
No, I am not. When I initially filed the complaint with the code enforcement, I did it as an individual, and I made that very clear in the original application.
Any further questions for the? Okay, thank you very much. We appreciate your time.
Thank you.
Now, is there anyone else wishing to speak in favor of this case? Is there anyone wishing to speak in opposition to this case? Please come up to the microphone. Make sure it's on, please. Yeah. Either one. Yeah, he does.
Mr. Taylor?
Check.
Mr. Taylor, can you actually use
The other
it's-
one?
Yes.
Sure. I'm not that tall, but I'll do my best.
Yeah, would you please raise your right hand?
Yes, sir.
You swear to tell the truth, the whole truth? Nothing but the truth?
I do.
Good. Please state your name and address for the record.
Mic's on. Okay, my name's Dan Taylor. Mr. Chairman, members of the board, good afternoon. Thanks for the opportunity to be here and to clear some things up. It's been a long road. This has been a 3-year process. I want to tell a short story and then I'll do a quick PowerPoint presentation and be here for any questions that you might have. I am lucky enough, I've lived in Tucson my whole life and Richland Heights East for 23 years. And I'm lucky enough to own 4 houses on my street. This is the latest house that I bought, which I bought from Mr. John Berryhill, who sadly had to move to get long-term care for Alzheimer's. He was one of my very best friends. He taught me how to weld in that shop, how to do sheet metal. He was a master of construction and a real mentor to me. About a month after I bought it, I had constructed a fence simply because Mr. Berryhill was a collector of things, if you will. He had a lot of stuff and I had to throw things away and most of it was garbage. So I built a fence for privacy to be able to pull stuff out to the front yard. I actually removed 3 roll-offs full of garbage in the first month, 40-yard roll-offs. So it was just a process of cleaning up. There's no construction work going on. The only thing I've built so far is a fence. I get a visit from a code enforcement officer at about a month after owning it. Building without permits was the complaint. After research done by the code enforcement staff, I received notice of violations for basically everything Mr. Berryhill built over the last 30 years. And it was a complete shock to me. I know it wasn't my neighbors because a lot of them are here and we're all family. And generally we address things person to person. If there's an issue, we take care of it amongst ourselves. So it was kind of a shock that this thing had come to pass, but here we are. So I immediately started submitting things to the city in order to become compliant, because I don't think tearing the shop down makes any sense to anyone. Contrary to the statements by Ms. Pollock, it is not a lean-to shed with a dirt floor. And with that, I can roll into the PowerPoint presentation. Mr. Castro, if you don't mind.
We're getting it right up for you now. Thank you.
Thank you very much. So this is the property as you'd see it today. This photo was just taken a couple days ago. If you look to the left, you will see the structure in question. It's got the gable roof attached to the main house, and that is the Mr. Berryhill's workshop. There has been an iteration of that shop in different forms since the house was constructed sometime in the early 1940s. Next slide, please. A little bit of history, I think. I've lived in the neighborhood for 23 years. I'm actually the vice president of the neighborhood association currently. I own 4 houses on that street, and I've spent a lot of money and time fixing them up. It's a fantastic neighborhood, and it's hopefully where I'm going to be forever. As I said, Mr. Berryhill was a longtime friend. He had to move to 24-hour care. My personal residence, 3437, which you can see in the second photo down, is built directly across the street from the subject property. Subject property purchased August 2022, code officer visit in September of 2022, and notice of violation in October of that year. I've sent in 3 versions or revisions of plan sets for permitting to development services. They've sent back comments. Of course, what's holding it up at this point is the zoning variance to bring it into compliance. The homeowners on the north boundary of the property granted the quitclaim deed, so they're the ones affected by it, and they're here today, and they were gracious enough, because they obviously want the shop to remain, to take the device of granting the quitclaim deed of that extra piece of property that we needed in order to make it comply. DDO, as you heard, was awarded by the zoning director in October, I believe, of 2024. And that's where we are today with the appeal. And the appellant is the same individual that called in the code enforcement complaint. Next slide, please. Just a little more history. There was a carport attached to the house, permitted in 1956. The carport has changed and morphed over the years, as things do, and has been taken down and rebuilt a number of times. But there's a precedent for a carport attached to that house since basically it was built or shortly thereafter. Next slide, please. Construction. This is where we're going to clear some stuff up. It's not a lean-to shed with a dirt floor, that's for sure. It's all steel. Mr. Berryhill is known to overbuild things, welded steel. There's rigid foam board insulation on the ceiling and the north wall. 6-inch slab, not dirt, with a 15-inch monopore footer. We've got 3 to 6 inches of urethane spray foam on the roof, which this is an important point. It's contiguous to the house. So you can see in that photo on the corner there, it is all one piece. So we have a solid roof membrane that if it were to be removed, could cause significant damage to the home, which is of course straw adobe and in pretty tenuous shape. It needs repair, and I'm capable of doing that. The rear shed, which has been around in some form since the 1960s, up and down, is welded angle iron, so also very strong with a steel siding. I did have to produce structural engineering documents in order to qualify for a building permit, because it's not built to IRC specifications. So one of the requests by Development Services was to get an engineer to sign off on it, which I did. So there's 76 pages of engineering saying that it's strong and pretty much overbuilt. Next, please. Okay, a little bit about the neighborhood. There's been some comments about how this would set a precedent for folks building on the lot line. That's not true at all. If you do an aerial shot of the neighborhood at large, and unfortunately the red circles I've drawn on these photos, they're not, resolution on the screen's not so great, But you can see just, this is a quick survey of a few properties in the neighborhood, and you can see a lot of folks are built right against the property line. Now, I think 20-foot setbacks are a good idea in a lot of for a lot of reasons, but it's kind of novel this day and age when the city becomes more dense. Folks tend to violate those setbacks. And in my case, I'm just trying to become compliant for something somebody else built. And let's see here. Mixed architectural style is very important. There's no consistent architectural style in that neighborhood. It's one thing that makes it kind of cool. It's very, it's varied in its design. There's not an HPZ there. There's no environmental resource zone, ERZ, and of course, there's no HOA. Next slide, please. This is important, excuse me. I have a lot of support from neighbors. The green boxes indicate signed documentation, either declarations or forms that the city mailed to them, indicating that they think that the appeal should be dismissed. The property should remain as is. I did a little canvas of the neighborhood in the limited time that I had, and basically everybody I talked to was kind of surprised that this was an issue to begin with, considering the workshop's been there for close to 20 years. Next slide, please. And these are just slides to show some of the support. That's an example of the declaration page signed by a lot of neighbors. It's very substantial, and I think that most neighbors would agree this should stay as is, especially those impacted. The appellant and also Maureen Pollock, who called in the code violation, doesn't really live near the property, so it's a little confusing as to why this occurred in the first place. I believe her opinion does not represent the majority opinion of the neighborhood, and hopefully in a brief period of time here, some folks will have a chance to testify to that. Next slide, please. And this is just another page of some of those declarations. Next slide. And that's it. So these are just some of the declarations I just scanned in to show that we have substantial support for this remaining as is. The sad truth is, if this appeal is allowed to go through, that's a death sentence to that shop. I need to tear it down. There's no way to make it compliant. There's no way to move it. It is overbuilt. It will be very costly to take it out and could cause a lot of damage to my home. So hopefully we can make this all, disappear eventually, and I can get on with my life. I've been unable to rent the house. I've been unable to sell the house. I've missed out on a lot of opportunities to renovate the house because it's been landlocked with this complaint for almost 3 years. So I'm looking forward to it ending. Happy to answer any questions that you might have.
Yes, Mr. Taylor, I have a question. Could you go back to that first slide that shows the property?
Mr. Castro is in control there. Thank you.
Yeah, keep going. Boom, bingo, bingo, bingo. Is that the front of the property?
Yes, sir.
Is that, how high is that wall?
Mr. Chairman, that's 6 feet.
6 feet?
Yes, sir.
Okay. Is there a driveway into it? Is there gates that open?
Those two panels that you see on the sides with the galvanized sort of artwork there, those are sliding gates, and those are 2 curb cuts which have been permitted. There was an existing curb cut on the left. I have a permit for the one on the right. So yes, there are 2 entrances to the
Thank
driveway.
you. Appreciate it.
And there's also a man gate in the middle there that's hidden because it's rusty. You can't see it. So
Thank you. I appreciate it.
yes, sir. Thank you.
Any other questions for Mr. Taylor? No further questions? Thank you, sir.
Thank you.
Appreciate your time.
Appreciate you. Thank you.
All right. Is there anyone else wishing to speak? The microphone, raise your right hand. You swear to tell the whole truth, nothing but the truth?
I do.
Would you state your name and your address?
My name is Nicholas Bush, B-U-S-C-H, 3454 North Wilson Avenue, 85719.
Thank you.
Good afternoon, Mr. Chairman and board members. I have owned and lived in the house next to Dan since 1972. So I've seen some changes in the neighborhood. The workshop and shed in question share our property line. Neither of those structures has had any negative impact on us at all, 0. My wife and I have absolutely no problems with the current placement or the continued existence of either of those structures. So obviously, I'm here to support Mr. Taylor and his zoning request. Any questions?
Are there any questions?
I have no questions, but I do find your testimony to be substantial and significant. Thank you.
Thank you, sir.
Any other questions?
May I comment?
Not yet, thank you.
Oh, okay.
Any other questions for him? Anyone else wishing to speak? And over the microphone, please. Raise your right hand. Do you swear to tell the truth, nothing but the truth?
I do.
State your name and address, please.
Tricia Foster. I actually used to live at 2434 North Wilson, the property on the other side of the property in question, but I'm currently at 2201 East Kleinedale Road on the corner of Kleinedale and Wilson. Thank you very much for giving me this opportunity to speak. I am in agreement with Dan, obviously, and support him. John Berryhill taught me also to weld in this shop and was a very generous person who did overbuild and made very strong structures. He helped a lot of neighbors and didn't charge anything. He built us, he helped us to build a trellis in our front yard, and I told him I didn't need to climb on it, but that's the kind of structure that he built. And Dan has been a neighbor as longer than Maureen has ever been in the neighborhood. And this has never been a problem. There isn't anybody else that really contests or even understood why Maureen is going after this. I was on the board also, and this was never an issue or a problem. Dan has done some amazing things in the neighborhood. He has helped out neighbors free of charge just because he's a good person. He's gone far and beyond being a neighbor, and he has done so much work for us and never charged us anything. And I love this guy. I love having him as a neighbor. I love what he's done. This house at Berry Hills, when he bought it, was a pack rat infested property that had so much garbage on it. It was so disgusting. And he has turned it around and he's fixed it up and he goes by the rules. And I'm just wanting you to know that I totally support him. And I can answer any questions if you have any.
Thank you. Are there any questions?
Yeah, I have one question, and you may not be able to answer this, but we've heard that the appellant is a member of the homeowners association, and you've indicated that you're a past member of
It's not a HOA.
neighborhood
Yeah.
association. Do you know whether the neighborhood association discussed this matter? I understand they have not filed the appeal, but did they take a position on this, or did they?
I am not currently on the board, and my husband is, but I don't believe that the board supports this at all. Maureen
Say
is,
supports this, you mean
Supports-
supports the appeal?
yeah.
Mhm.
So Jessica Walker and Dan are both on the board. You could ask them. I don't
Currently,
believe.
they are.
Currently, and I don't believe Maureen's been on it for 14 years. I think it's been a lot less than that, but I don't know. I don't have the minutes, and I haven't been on the board for at least that long, so.
Okay, no, that's fine. Thank you very much.
Thank you. Is there anyone else wishing to speak in favor? Please raise your right hand. Do you swear to tell the truth, nothing but the truth?
Yes, sir.
Could you please state your name and address?
My name is Regula Case. I live at 2202 East Greenlee Road, which is 2 houses up from the one we're talking about.
Okay.
there are neighbors and there are neighbors. I'm alluding to what she just said. Some neighbors want every little I dotted and every little T crossed. Other neighbors are there to help you in times of trouble and in times of joy. I'm here to agree with Trish. Dan is of the later sort. Maureen used to be the president of the neighborhood association. It's not a homeowners association. And she's very diligent. She was a very good president. Sometimes she does her job, she no longer is, a little too well. And that seems to run with the territory because that typified another woman who also did the job a little too well, which means get in your face, get in your business. Maureen, as you may know, is the owner and president of Maureen Construction Company. So she may see Dan as a threat. I don't think so, because they work in different spheres. But I'm here for Dan because he has done nothing but good for the neighborhood. I too am so grateful to him, if for nothing else, getting rid of all those pack rats. But he's done so much more. He's always there in a time of need. He's a wonderful person, and he does everything beautifully, beautifully. I've submitted a letter. I hope you read it. Thank you.
Are there any questions for the,
I did read that letter. I read the letter.
thank you. Anyone else wishing to speak in favor? Seeing none, I will now offer the applicant to have a rebuttal.
Thank you. Can you hear me?
Yes?
Oh, great. Thank you so much. I would just like to remind the board and Mr. Chairman that this is not a personality contest. This is a non-compliant structure in the neighborhood. Mrs. Chase is correct that I am in the construction business. I do inspections and plan review and provide due diligence for affordable housing throughout the United States, and I've done that for the last 10 years. I will tell you that I know new and recent improvements from old improvements, and the shed that Dan Taylor showed us in his pictures was not the shed that codes enforcement saw on October 22nd. That material inside that shed is new. And if it's new, it was done without permitting. And just because it costs money should not be the issue. Mr. Taylor took that risk by not permitting this shed to begin with. The other thing I would like to point out is we are not talking about neighbors here. We are talking about developers. And why are developers giving precedent over residents who live in the neighborhood? Oh, and the last thing, I was glad Mr. Taylor showed the aerial of all of those properties that are on the property line. They are sheds. They are man-made sheds that people put on their property. I have my own. And all of a sudden the sheds they get a life of their own and they start becoming part of the property. We have several of those, but the ones that were shown on that aerial that Dan said, if you zoomed in on them, I would imagine they are freestanding man-made sheds. And that's all I have to say. Thank you.
Thank you. Is anyone else wishing to speak in? Raise your right hand, please. You swear to tell the truth, nothing but the truth? See your name and address, please.
Dawn, can you hear me there? My name is Charlene Paul. I live at 3454 North Wilson. And our property is on the same line with the sheds that are in question. Everything that everyone has said is completely the truth, except there was much more. Mr. Barry Hill had a junkyard. Cars, trucks, wheels, vessels that collected water. We had an infestation of mosquitoes, pack rat middens beyond belief. The stench that came from this property was overpowering. Sometimes we'd have to leave. Dan Taylor cleaned it all up. Now, what Maureen Pollock said about Dan improving the sheds since he bought the property is untrue. He has done nothing to those sheds except for cleaning out the garbage. But as far as the buildings are concerned, they are the same structures that Mr. Berryhill put up. So she's mistaken there. He has done nothing to change those sheds except for cleaning them up. So I just wanted to make that clear. So are there any questions?
Thank you. Any questions? None. Thank you, ma'am.
Well, thank you for having this.
Anyone else wishing to speak? With that, I will close the public hearing on this case. And open the floor to discussion from the board. Anyone? Okay. Then I will ask for a motion, please.
Yes, I move that we uphold the PDSD Director's decision to approve DDO 24-81 in case C10-2407. That includes DDO approval to allow the side perimeter yard setback to be reduced from 20 feet to 1 foot 6 inches, measured from the workshop to the north lot line. 2, DDO approval to allow the side perimeter yard setback to be reduced from 20 feet to 4 feet 6 inches, measured from the shed to the north line. And 3, DDO approval to allow the rear perimeter yard setback to be reduced from 20 feet to 8 feet 4 inches, measured from the shed to the east lot line, all as shown in the submitted plans. The evidence presented to the board shows that the director's decision was not based upon an error and that the project is in compliance with all DDO general and specific findings as set forth in the staff report on pages 3 through 5.
Thank you. Do I have a second to this motion?
I'll second that.
Yeah, he's been moved and seconded. Is there any discussion on the motion? Hearing,
I do have a concern. When we permit this kind of elimination of a setback for something that is billed as a workshop, I have a great concern about what the future use of that building might be. And someone may not object to a property, a building on the lot line if it's a workshop, but they may object to it if it becomes a sleeping quarters or an accessory dwelling unit. And I think this kind of remedy for someone who bought a piece of property, probably knowing that the structures on there were not permitted, because people in construction tend to know how to do due diligence. I find it very interesting that we as a community have decided that this is a way to bring such properties into compliance. And I understand the motion. I believe that there was no error, but that still doesn't make me happy that this is the way we proceed with things.
anything else? I'll call for a vote. All those in favor, say aye.
Aye.
Aye. All those opposed? None. The motion carries. Thank you very much. Okay, what is the next case, please?
Thank you, Mr. Chair and members of the board. Our next case is C10-24-08, Chick-fil-A New Awning, Solar Holdings LLC, 4585 North Oracle Road, C3 zoning. The applicant's property is an approximately 1.37 acre lot, zone C3 commercial, and is developed with a restaurant. The applicant is proposing to construct a new drive-through shade canopy as part of a remodel to the building. The applicant is requesting the following variance: to allow the shade canopy to be constructed with the street perimeter yard setback reduced from 10 feet to 4.5 feet as measured to the east lot line, all as shown on the submitted plans. Planning and Development Services staff has no objection to the applicant's requested variance. It is the opinion of staff that there are special circumstances applicable to the property and that the reduced street perimeter yard setback would not constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity and zone and would not be detrimental to public welfare or injurious to other property or improvements in the neighborhood. Today, we have received a total of 1 written approval, 0 protests, and for the record, board members have been provided a copy of the comment. Mr. Chair and members of the board, this concludes staff's presentation. I'd be happy to answer any questions.
Any questions for staff? No questions. Thank you. Is there anyone wishing to speak in favor of this case? Seeing none. Anyone wishing to speak in opposition to this? Well, that's what I asked. Is there anyone from the?
Mr. Chair, we have the applicant attending the meeting by Zoom.
Okay, then I'm sorry I moved on too quickly. Where is are we seeing a picture of him?
Mr. Dawson, if you could turn on your camera, please.
Yes, sir. My apologies.
Okay.
Hello, everyone.
Raise your right hand, please. Do you swear to tell the truth and nothing but the truth?
I do.
Thank you. Would you state your name and address for the record, please?
Yes, my name is Ian Dawson. I live at 3107 Vine Circle in Rockland, California. I'm here with other members of our team here supporting Chick-fil-A to answer any questions that you may have for us.
Are there any questions?
Yeah, I'd just like to ask if you could explain the need for the variance request.
Absolutely. I also have Ali Fedor from our civil engineer. If Ali, would you feel comfortable sharing a little bit more about that?
Who is this?
Our civil engineer.
Yeah, I can.
Sorry.
Can you guys see me?
Would you raise your right hand?
Yep.
Do you swear to tell the truth and nothing but the truth?
Yep.
Proceed.
Yeah, so the reason why we're going in for this variance is due to some improvements that we're wanting to do on the site. Oracle Road has been, Auto Mall has been extended from what it originally was. And so the setback has changed from what it was when the building was originally done. So we are asking for the variance to allow for the canopy to go into the setback where it previously wasn't when the building was originally constructed.
Okay, I have a question. Is there, I noticed in the plans that I observed that there are 2 drive-up lanes there. Is that what was driving that, and why can't you just have 1 lane and really no need for the variance?
So the need for that is to allow for a bypass lane for people who get their food before others. At the entry of the drive-through, we do have 2 lanes as well, and that is to allow for additional queuing, so then we're not going on to any of our neighbors' sites.
Okay, thank you. Are there any other questions?
Yes, I have one question of the applicant. On your required findings, you state that this is not any special or unusual treatment for your other restaurant locations. Do your other restaurant locations in Tucson have canopies that cover the drive-through areas? And if they do not, is this something that you're planning to do to all of your facilities that you have here in Tucson?
So I know we are doing it to another Tucson location, Elcon, and then Ian, I don't know if there are any other sites. If you could answer that one.
Ali, yeah, I agree. The two that we are working on are the Elcon and this project in Tucson. It is Chick-fil-A standard to have those 2-lane drive-throughs are something that they are doing, and always to have the canopies over those 2 lanes.
Not really sure how you're gonna get 2 lanes on that Elcon location, but I don't know. Any other questions? There are none. Okay, hearing none, thank you very much. Is there anyone else wishing to speak in favor of this case? Seeing none, is there anyone wishing to speak in opposition to this case? Hearing none, let's move on.
I do have one question I'd like to direct at staff, and that is it correct, the variance is only necessary because of the canopy that's being proposed? There could be a driveway within that setback if there were no canopy, is that correct?
Mr. Marks and members of the board, that is correct.
Okay, okay, thank you. And the canopy proposed, I apologize for not looking at the plans closely enough, but is it the entirety of the driveway or is it just a segment of the driveway? Because I am familiar with other Chick-fil-A's and really there is none that I can recall locally where there is a continuous canopy for the entirety of a driveway.
Mr. Marks and members of the board, it's just for a portion of the driveway. It's just south of the building facade. I guess the front of the building is where it's at. I guess as right as you're coming in from the parking lot, the canopy is right there. I
Okay.
guess right before you go around to the building to the drive-through window.
So generally what the dimensions of that canopy are what? I see it now and do you have any general dimensions we were talking about?
So it is a, if I may speak, the canopy is a 1,400 square foot drive-through canopy. The one in question is the one at which team members would be taking orders from customers. And that's usually that first canopy that Mark was talking about. The second one is at the order pickup. And so at both of those locations, we have team members outside serving the customers. And that's one reason for those shade canopies is for their protection from the sun.
I'm okay with the answer.
Are there any other questions, please? Hearing none. I will now close the public hearing with regards to this case. I'm looking for a motion.
I'll make the motion and I move that we grant the following variances in case 6C10-2408 to allow a shade structure to be constructed with a street perimeter yard setback reduced from 10 feet to 4.5 feet as measured to the east lot line as shown on the submitted plans. The evidence presented to the board shows that there are special circumstances which were not self-imposed, which are applicable to the property and support the granting of the requested variance. As set forth in the staff report, Board of Adjustment findings 1 through 7, the variance with will not be material detrimental to the public welfare or injurious to other property or improvements in the neighborhood and is the minimum necessary to provide relief.
I'll second.
Okay, it's been moved and seconded. Is there any discussion on the motion? Hearing none. All those in favor say aye.
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 All those opposed? None. Motion carries. Thank you and good luck with your project.
Thank you very much.
Okay. Next case.
Mr. Chair and members of the board, our next case is C10-24-09. Anderson Residence Accessory Structures, David Anderson, 1 North Tucson Terrace, R2 zoning. The applicant's property is a 0.66 acre size lot zoned R2 residential and is developed with a single-family residence and several accessory structures. The applicant is seeking zoning approval necessary to allow the accessory structures to remain as constructed, in addition to constructing a new fence. The applicant is requesting the following variances. 1, to allow the cistern to remain in the front yard. 2, allow the attached shade structure to remain with a front street perimeter yard setback reduced from 20 feet to 2 feet as measured to the south lot line. 3, allow the attached shed to remain with the front street perimeter yard setback reduced from 20 feet to 6 feet as measured to the south lot line. 4, allow the cistern to remain with the front street perimeter yard setback reduced from 20 feet to 0 feet as measured to the south lot line. And 5, allow the privacy fence to be constructed along the west lot line at a height of 13 feet, which exceeds the 6-foot maximum height, all as shown on the submitted plans. In related case, code enforcement, case number CE-VIO-0923-05390 is a code enforcement case that was initiated for an unpermitted fence and several accessory structures. The case is active and is pending on obtaining permits and zoning approval for these structures. Planning and Development Services staff has no objection to the applicant's requested variances. It is the opinion of staff that there are special circumstances applicable to the property and that the requested variances would not constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity and zone, and would not be detrimental to the public welfare or injurious to other property or improvements in the neighborhood. To date, we have received a total of 5 written approvals, 0 protests, and for the record, board members have been provided copies of the comments. Mr. Chair and members of the board, this concludes staff's presentation. I'd be happy to answer any questions.
Thank you. I will open the public hearing on this then. Is there anyone wishing to speak in favor of this case?
Mr.
I'm
Chair,
happy
we do
to-
have the
Go ahead,
Okay,
Mark.
good. Would you raise your right hand, please? You swear to tell the truth and nothing but the truth.
I do.
Good. Would you state your name and address?
Yeah, my name's David Angus Anderson, and I live at 1 North Tucson Terrace.
Okay, let's hear what you have to say.
All right, can I share my screen?
Yes?
Yes, we'll get that ability to you in just a moment here.
Great, thanks. All right. Can you all see this?
Yes.
Okay. So I'm just going to talk about some of the odd circumstances of this property and why I'm seeking these variances. The front and the backyard have switched places, and that's the biggest one relating to the accessory structures. This property was basically platted in about 1909. At that point, the main access was from Silverbell, which was a dirt road with nothing on it. And what is currently the stub of the driveway used to be a road called North Tucson Terrace, which no longer exists. So my address is actually on a non-existent road, which used to run straight through my yard. I'm not sure when that went away. It may have been the 1940s or 50s. But at some point, the Silverbell egress was closed off and egress was just on West Tucson Terrace. And so I want to show you, the house is actually built facing north. This is the front yard. To the left, or this is the front door. To the left, you can see what's left of the driveway. That used to be North Tucson Terrace. And you can see in older pictures that accessory buildings have been behind the house. So that's the south side, which is now considered the front yard, for quite a while. This is 2005. And then because I'm a historian and I found the relatives of the residents who had the place in the 40s until the 80s, they give me some pictures. This is the only one I can find, but it actually shows there was an accessory structure south of the building, I think in the mid-1960s. This is a shot from West Tucson Terrace. So I have a 6-foot fence out front. My lot is recessed down below. And as you can see, like essentially none of the accessory structures are even visible. The cistern is not. And this is on the inside. You can see that things are actually set back from the fence and are quite low. So that's what I wanted to address there. The fence is the other thing I wanted to address. And because it's put in as 13 feet, which sounds quite extreme, I want to explain the circumstances behind this. The lot to my west in 1985 got a permit from the city, and they brought in about 6 feet of fill. So they are 6 feet above grade at the north end of our lot. At the south end, we're pretty close to the same grade. And they built a retaining wall. And then because of basically code issues, they could not do a retaining wall plus a wall topping that exceeding 10 feet. So in the area of maximum fill, they have 6 feet of retaining wall and just a 4-foot block wall. And then over on my side, I'm facing 10 feet. This has created issues, several issues, one of which is that over the last 11 years, people have dumped a lot of stuff into my property. We're talking like pallets, motor oil, all sorts of things, because it's generally been desert and it just gets thrown in there down this hole. I've had people jump into the property and get stuck, and then they're just in my yard with me. And so after a recent, this was a couple years ago, but a burglary where someone just hopped over the low fence on their side and then got into my yard and was loading things out. So they came in, they were able to survey it at the high end, and then they exited through the low end. I put up a 2-foot corrugated extension atop their wall, bringing it up to 6 to 7 feet from their side. And so that's what I'm seeking the variance for today. And this would be, the way I'm setting it up, this would be going fully up from my side. Currently, it's bolted onto their wall. But really, when I'm asking for 13 feet, I'm asking for, from their side, only a 6 to 7 foot privacy fence. 7 is, I think, appropriate for the situation because they are 6 feet higher than us, so we're actually down in a hole vis-a-vis them. And I just want to show, this is actually the most extreme area. Because the west lot is going to be basically built out with 2-story townhouses, obviously this fence isn't going to obscure their view of anything. They're going to look well over it into our yard and into the city beyond. And I think it's warranted to go from 6 feet to 7 because of privacy. So the image on the right here shows you kind of the field of view of ours that's going to be occupied by these houses. So I don't feel like that extra foot will be a problem for them. If this was a normal wall, I would just go for a DDO and ask for a 7 or 8 foot fence there. But because of the strange circumstances with the retaining wall, I have to ask for the variance. In terms of aesthetics, I just want to address this briefly, but the lot to the west has been unbuilt for the past 40 years. As you can see, it just doesn't have a lot of aesthetics. So, you know, putting up the 2 extra feet or 3 extra feet of corrugated there is not going to change the neighborhood. There's corrugated fencing everywhere in Menlo Park. So that concludes what I had to say. And let me stop screen sharing here.
Thank you. Are there any questions?
Yeah, I have one. I just like to get a little more clarification on the wall. So as I understand it, the owner of the adjoining property added fill up to the property line, the common property line at some time in the past, and built a retaining wall up to the adjusted grade, to the top of that grade. And so your wall, I take it as not an extension of the existing retaining wall. It's going to be adjacent to the existing retaining wall. Is that correct?
Correct. So it will actually be potentially 13-foot tall poles with 2 feet of fencing at the top of them.
What kind of gap is there between the fences, the walls?
Presently, I'm bolted into their wall, so there's no gap, but there would probably be, I would think, you know, a couple of inches.
So from the existing top of wall on your adjoining property to the top of the wall on the new wall on your property, what is that distance?
Oh, you mean like how high would mine float?
How much
above it?
taller is your wall than their wall? Your maximum wall is 13 feet. But I think what I heard you say is it's not consistently 13. It's adjusted due to the grade on the adjoining property, which changes.
Significantly, yeah. It would go down to like at the low end on the south part of the yard, it would probably be, I would have like a 7-foot post. But on the north end, I would have a post that would be 13. And something I forgot to mention here, but they're actually contiguous with this wall. They have an 8-foot section already by the pool. So that's at the far north end of the yard. And I didn't, I wouldn't be building anything there because they've already gone up to 8 feet with block. So there's certainly a precedent for going over 6. But again, from their side, it would only be 7, maybe 6, because
6 to 7
the ground
feet.
is very variable. Yeah. So pretty much a
On their side.
on their
Okay.
side. Yeah. So
Okay.
I'm kind of stuck. I mean, I'm not someone who likes 13-foot tall fences in his backyard, but we're just kind of stuck because if we built a normal fence, it wouldn't even begin to approach the height of their wall.
Okay. Okay. Thanks. I understand now.
Any further questions for the applicant? None. Thank you very much. Appreciate
Okay.
your time.
Thank you all.
Thank you. Is there anyone else wishing to speak in favor of this applicant? Hearing none. Is there anyone wishing to speak in opposition to this case? Seeing none, hearing none. I'll open the floor to any questions. Do a motion then.
Did you close the public hearing? Did you close the public hearing?
Oh, yes, my apologies. I'll close the public hearing in this case then. Thank you for keeping me on my toes. So I will now ask.
Mr. Chair, I move that we grant the following variance in case C-10-2409. 1, to allow the cistern to remain in the front yard. 2, to allow the attached shade structure to remain with a front street perimeter yard setback reduced from 20 feet to 2 feet as measured to the south property line. To allow the attached shed to remain with a front street perimeter yard setback reduced from 20 feet to 6 feet as measured from the south lot line. To allow the cistern to remain with a front street perimeter yard setback reduced from 20 feet to 0 feet as measured to the south lot line. And finally, to allow the privacy fence to be constructed along the west lot line at a height of 13 feet, which exceeds the 6-foot maximum as shown on all the submitted plans. The evidence presented to this board shows that there are special circumstances which were not self-imposed, which are applicable to the property and support the granting of the requested variances. The special circumstances, as I said, were not self-imposed. There are special circumstances on the property, including the change in the ingress and egress to Silver Bell Road, the size, shape, and topography of the site, and that the variance is granted is the minimum variance that will afford relief and is the least modification possible under the UDC provisions. The variances will not materially be detrimental to the public welfare or interest to other property or improvements in the neighborhood, and is the minimum necessary to provide relief.
I need a second.
I'll second.
Been moved and seconded. Is there any discussion to this? Hearing none. I will call for a vote then. All those in favor of the motion?
Aye.
Aye. All opposed? None. Motion carries. Good luck with your project, sir.
Thank you very much.
Okay. Next case. One to go.
Thank you, Mr. Chair and members of the board. Our next case is C10-24-10. Clark Residence, new sleeping quarters and shed. Bruce Clark, 345 South Irving Avenue, R1. The applicant's property is a 13,939 square foot lot, zone R1 residential, and is developed with a single-family residence and accessory structures. The applicant is proposing to construct a new addition to the existing sleeping quarters and requesting zoning approval for a detached shed in the front yard. The applicant is requesting the following variances. 1, allow the 4 required parking spaces based on a total of 6 bedrooms for the site to be located in the front yard. 2, allow the detached shed to remain in the front yard. And 3, allow the sleeping quarters addition to be constructed with a reduced side perimeter yard setback from 6 feet to 4 feet 2 inches as measured to the north lot line, all as shown on the submitted plans. Planning and Development Services staff has no objection to the applicant's requested variances. Should the board approve the requested variances, staff recommends the following condition. A, for the entirety of the life of the shed located in the front yard, an opaque fence of a minimum 6-foot height shall remain to screen the shed from the street. It is the opinion of staff that there are special circumstances applicable to the property and that the requested variances would not constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity and zone, and would not be detrimental to public welfare or injurious to other property or improvements in the neighborhood. We have received no comments for this case. Mr. Chair and members of the board, this concludes staff's presentation. I'd be happy to answer any questions.
Any questions for staff?
Yeah, I do. The first variance has to do with the parking spaces, and it's based on a total of 6 bedrooms for the site. Can you tell me how many of those 6 bedrooms already exist and how many are in the sleeping quarters that are being proposed?
Mr. Marks and members of the board, I believe right now 4 bedrooms exist. So the 2 bedrooms would be the sleeping quarters. And let me just pull up the map here.
So the parking spaces to serve the existing 4 bedrooms, are they in the driveway, or are they're not designated spaces off a street?
Mr. Marks, to clarify, in a single-family home, the required parking spaces can be satisfied in the driveway. When it hits a 5-bedroom threshold, there's a requirement for additional parking spaces, and they're supposed to be provided not in front of the house, either to the side or the rear. So the variance request is to have those parking spaces all provided in the front of the home.
Okay, so under the code, you can have a maximum of 4 spaces in front of the house.
It's not based on a maximum number in front of the house. It's when you are required more than 2,
Hmm,
those extra ones need to be outside of the front yard.
Okay, okay. And this sleeping quarters that's being proposed, is this an addition to the house or is this a freestanding structure?
Mr. Marks and members of the board, it's a freestanding structure. There is an existing sleeping quarters that's located in the rear yard. This addition is attached to the existing sleeping quarters, but it's not going to be attached to the residence.
Okay. All right, thank you.
Yeah, I have one question. We're talking about these, the threshold is 5 bedrooms, is it not? And I had understood one time, because I had a number of houses near me that were quasi dorms or frat houses, because they were always being occupied by students in and out every semester. And you get a new group in, and you get them. We had a little red tag alley going back there because of their parties. And but I understood that when it hits 5 bedrooms, that those parking spaces are required to be on site, not on the street. Is that, am I correct in that assumption?
That's correct, Mr. Chair. They do need to be on site and they need to be located in the side or rear yard.
Thank you. Any other questions for staff?
No, I don't.
Okay, I will now open the floor to anyone wishing to speak for in favor of this case. Please raise your right hand. You swear to tell the truth and nothing but the truth?
I do.
Good. Would you state your name and address?
My name is Hogue Day. I live at 4041 North Pontotoc Road. I'm here representing the owner, Bruce Clark. I'm an architectural designer.
Microphone on.
Can you hear me? I'm sorry. This up in this place. I'm here representing the owner, Bruce Clark. I'm an architectural designer. I did the plan set and did the application. We're here just to basically answer any of your questions. To address the 2 questions that have already been raised, I wonder if we could pull up the application with the site plan. And just to be clear, there is an existing sleeping structure already. It's extremely small. It's about 250 square feet. So it's basically a single room and a bathroom. It was constructed in 1998, I believe. It was set when Bruce bought the property, it was already in place, as well as the shed in the front. So both of these structures were already in place before he purchased the property. The sleeping structure, the sleeping quarters rather, was already, this is in terms of the reduced setback, was already set at 4'2" from the north property line. This isn't, what we're proposing is an addition, a 500 square foot addition to the sleeping quarters, the existing sleeping quarters, to make them more livable. Okay. Right, so the requirement, so the, I think technically the property already has 5 bedrooms, because as you probably know, it's a very strict, or it's a very, how do I put it? What zoning considers a bedroom is any room, right, of a certain size that doesn't have, say, a 5 foot wide, access archway. So it's any room that has a door that can close, essentially, that's not being used as a bathroom or a kitchen. So with that in mind, Bruce, my client, uses, for instance, one of those rooms as a utility room, but zoning considers it a bedroom, and that's within their rules. The requirement for parking, as I understood it, was a response to the creation of so-called mini dorms. This house is not close enough to the university, in our opinion, to become a mini dorm. And given the change in the status of housing around the university, don't foresee that as a real problem in this neighborhood. There isn't really a pattern of that happening in this neighborhood of students piling into, a house with a bunch of bedrooms. The reason we're asking for the variance in terms of putting the parking in front is because, as you can see, although a lot of it's blocked, it's impossible to put parking anywhere else, unfortunately. The setbacks on the sides of the existing house are too small to allow cars to come and go. So you can't actually get cars behind the house. The only place to put them is in the front. What's advantageous as far as we're concerned is the fact that the existing driveway is already big enough to accommodate 4 spaces if those cars are parked in tandem. So nothing in terms of the facade of the house would change to accommodate that extra parking. It already has a gravel cover. It already meets the code requirements in terms of the UDC. So I hope that addresses some of the questions about parking. Are there any other questions?
Yes, I have a question. Any concern about sequencing for parking like that? You gotta get somebody out of the other house to move the car so you can get out of here.
Yeah, I mean, the idea would be that it would be a family situation. In terms of Mr. Clark, in terms of Bruce, lives there by himself. He only foresees having one other person in the sleeping quarters in the back. He's done this he's aging in place and is disabled and would like somebody on site to be there to help him, basically. So it would be a low-income rental to have someone there to help him. So except that, in the change of ownership, that may be more of an issue, but if it's a family situation, we feel like that's not going to be onerous in terms of stacking cars somewhat.
So let me ask, are the things that you're adding are bedrooms, correct?
So we're adding one living room, essentially. It's supposed to be used as a living room. The zoning considers it a possible bedroom because it's not a kitchen, because it's because it's a sleeping quarters. It does not have an actual kitchen. In that case, then it can be considered a bedroom. But what he really wants it to be is a living room, essentially. It'll have a cooktop and a small sink.
So it'll have a small city, so there would be the possibility of having cooking facilities.
Nothing more than a small sink and a hot plate, essentially. Yeah.
So it could be rented as a small apartment or. an
Exactly.
F&C.
Yes, that's the plan. Yeah.
Thank you.
Sure.
Question? No, I don't.
Thank you, sir.
Thank you.
Appreciate it. Anyone else wishing to speak in favor of this? None. Anyone else wishing to speak in opposition? Seeing none, I will now close the public hearing in this case. Look for a motion.
Well, I'll make the motion. I move that we grant the following variances to case C-10-2410 for the following 3 variances. 1, allow the 4 required parking spaces based upon a total of 6 bedrooms for the site to be located in the front yard. 2, allow the detached shed to remain in the front yard. 3, allow the sleeping quarters addition to be constructed with a reduced side perimeter yard setback from 6 feet to 4 feet 2 inches as measured to the north lot line as shown on the submitted plans. Subject to the following condition. A, for the entirety of the life of the shed located in the front yard, an opaque fence of a minimum 6 feet height shall remain to screen the shed from the street. The evidence presented to the board shows that there are special circumstances which were not self-imposed, which are applicable to the property and support the granting of the requested variances, as set forth in the staff report, Board of Adjustment findings 1 through 7. The variances with the condition imposed will not be material detrimental to the public welfare or injurious to other property or improvements in the neighborhood, and is the minimum necessary to provide relief.
I'll second the motion.
Has been moved and seconded. Is there any discussion on this motion? Hearing none, I'd like to call for a vote. All those in favor of the motion, say aye.
Aye.
Aye. All those opposed? There are none. The motion carries. Good luck with your project. All right. I'm looking for my agenda. That's the last case. Is there any other business?
Mr. Chair, there's no other business.
Then we are adjourned. Thank you.
Thank you.